Hi everyone, my name is Kate Levesque. I'm a partner here at Husch Blackwell in our St. Louis office, and I specialize in labor and employment law, working frequently with clients in the higher education field. We're excited to be talking with you today about common scenarios that arise when employees request leave and accommodations. During our webinar this afternoon, we are going to interactively evaluate the options for responding to these real-life scenarios while maintaining compliance with the Family and Medical Leave Act, the FMLA, and the Americans with Disabilities Act, which you probably know as the ADA. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I would like to take a moment to highlight a few of the key icons for you. If you have any questions during our webcast, please submit your questions via the question box. I will try to answer all of the questions that I can during the webcast today, but if a fuller answer is needed or if I run out of time, I will make sure to answer your question later via email. I definitely appreciate audience participation, and I encourage you to submit any questions that you have throughout the presentation today. There is also an icon to assist with your viewing preferences. Please note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area to make it larger or smaller. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck and additional materials are available in the resource list icon that looks like a folder at the bottom of your screen. The program has been approved for Colorado, Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin Continuing Legal Education Credit and HR Certification Institute and Society for Human Resource Management Recertification Credit. To report your hours in Illinois, Indiana, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you, and that will come along with your certificate of attendance. So I am a self-described FMLA and ADA nerd, and because of that, I field many client questions and issues related to leave and accommodation requests from employees. I understand that often when we're dealing with these issues, we're operating in the gray area. There aren't any black and white answers. There isn't a clear way to move forward, and that's most of the time why you're contacting your attorney. So I assist clients with the practical solutions to respond to some of these more dicey leave and accommodation requests and questions, and I attempt to curb abuse with the laws. So before we move into the scenarios, I'm going to start with just a few basics about both the Federal Family and Medical Leave Act and the Americans with Disabilities Act. And I'm doing that just to make sure that we're all starting from the same point. And then we're going to jump into some of the common scenarios that I've seen. We will use polling in the webinar to interact together and to discuss the different options that might be considered for each scenario and discuss some of the risks and the benefits associated with each solution that's being presented. I'll mention that today's presentation will not focus on state family and medical leave laws, nor will we focus on individual state disability or pregnancy accommodation requirements. While much of our discussion is going to apply to state-specific laws, to the extent that your state law is broader than the federal law, we would of course modify the approach to comply with your individual state law. Also, I should note that to the extent you are not an institution of higher education or any other type of educational institution, you will still find this presentation to be informative because many of the scenarios are not necessarily specific to one type of institution or another. You will likely be able to find something in these scenarios that would apply to your organization as well. So let's start with a few basics about the FMLA. The first thing is who is eligible. Employees are eligible for FMLA leave if they have been employed for 12 months, and that's not necessarily consecutive months. A break in service of less than 7 years is generally included. So if someone was employed with you a year ago, they thought the grass was greener somewhere else, and then they realized that of course the grass was never greener anywhere else, and they came back to join you, they would just need to have been employed for 12 months. In addition, they have to have worked 1,250 hours in the last 12 months. And that is where you would want to look back at the preceding 12 months before the first date of leave and determine whether the employee worked the required number of hours. If not, then the employee is not eligible for leave, and if so, then the employee is eligible, provided that they work at a location where 50 or more employees are employed within a 75-mile radius. And so those are the 3 eligibility requirements under the FMLA. Now let's look at qualifying reasons for leave. Employees are entitled to 12 weeks of unpaid leave for the birth of a child, the placement of a child for adoption or foster care. And I should note that this leave related to the birth of a child or the placement of a child for adoption or foster care is not just maternity leave, but it's also available for parents for bonding, and that's parents of both genders. The care of a child, spouse, or parent with a serious health condition, or the employee's own serious health condition. And on the next slide, we'll talk about what a serious health condition generally is under the FMLA. And then a qualifying exigency arising out of the fact that a spouse, parent, or child has been called to active military service. And under the FMLA, a qualifying exigency can be a number of things. For example, short notice deployment, up to 7 days of leave can be taken when a family member receives notice of 7 days or less of a call to active duty. Individuals can take leave for military events and related activities, to make child care and arrangements and to attend school activities, to provide or to find care for a military member's parent. Now that is not to take a significant amount of time off because, say, the primary caretaker has been called to the military. This leave is to make arrangements for alternative care. So to go interview daycares or to go interview long-term care providers for the covered military member's parent. So it's not to take 3 months off to actually provide the care, it's to make arrangements for it. To make financial and legal arrangements, to attend counseling, to be with the service member for R&R or rest and recuperation, post-deployment activities, and other activities that are generally related to the active duty of the covered military member. So that's there. It's not used very often. It's often forgot about because we think about family and medical leave as actually being for medical leave, but this qualifying exigency is something additional. A serious health condition is defined as any period of inpatient care or an injury or illness that requires continuing treatment by a healthcare provider, and that's defined in multiple different ways, including permanent or long-term conditions that might not require much treatment or might not necessitate much treatment at this point. Some examples of serious health conditions include pneumonia, surgery, broken bones, severe morning sickness, asthma, depression, migraines, cancer, severe arthritis, terminal illnesses, or even substance abuse if the leave is related to obtaining treatment for that substance abuse. Some things that are not serious health conditions, the common cold, the flu, cosmetic treatments, unless the cosmetic treatment is related to a serious health condition or requires inpatient care. The upset stomach, routine dental problems, minor ulcers, headaches other than migraines. Those sorts of things are generally not considered serious health conditions. In addition, there is a period of 26 weeks of leave, of unpaid leave, to care for a service member and certain covered veterans with a serious injury or illness that occurred or was exacerbated in the line of duty. And that's available to spouses, parents, children, or next of kin of the covered service member. So again, that's out there. We're not going to spend a lot of time on that today, but I wanted to note it just in case it ever comes up for you. So let's talk just very quickly about the Americans with Disabilities Act. The ADA prohibits discrimination based on actual or perceived disabilities, and then it also has that component of requiring the interactive process and reasonable accommodations for employees with actual disabilities. And individuals are covered if they have a physical or mental impairment that substantially limits their major life activity, they have a record of having that type of impairment, or they're regarded as having that type of impairment. And so let me give you just a couple of examples. Examples of disabilities generally include intellectual impairments, cancer, diabetes, depression, alcoholism, prior drug addiction. In other words, the person is no longer using illegal or illicit drugs, but has a history of that. Epilepsy, even if it's controlled by medication. Dyslexia, even if it's overcome through education. And severe pregnancy complications. All of those things are considered disabilities under the ADA. Some things that aren't disabilities, they're actually fairly common to what's not a serious health condition under the FMLA. The common cold, the flu, visual impairments that are corrected by glasses or contacts, a sprained ankle that's going to heal fairly quickly, the current use of illegal drugs, minor broken bones, minor gastrointestinal disorders, a normal pregnancy, compulsive gambling. Those sorts of things are not covered as disabilities under the ADA. So now that we're all kind of up to speed and together on the background of who's covered and who's eligible, let's move into some of these scenarios, and then we'll talk and we'll go through some poll questions to help with our discussion. So our first scenario relates to Nancy. Nancy informed us last week that she has cancer and she will need to undergo treatments every few weeks. Nancy anticipates that she will be absent on the day of each treatment and for a few days following each treatment. Nancy is a long-term employee, and so she has a lot of paid time off that's available to her. She doesn't want the time designated as FMLA leave. What do we do? So in this scenario, Nancy needs to take some time off for something that we know is a serious health condition, and we know that we should designate it as FMLA leave, but Nancy has a lot of accrued but unused paid time off, and she just wants to take that instead of FMLA leave. And so what would you do to respond to Nancy's request? Would you just allow Nancy to use the PTO without taking FMLA leave, or would you somehow designate the leave as FMLA leave? And I'll give you a chance to respond and think through that answer. This is actually something that I come across fairly consistently. This is something that we generally see quite a bit. And while you look at that time, or while you look at the question and you answer, I'm going to answer a couple of questions. One of the questions that we've gotten is, what if your child is married and has a serious health condition and they need you? So the FMLA covers children under the age of 18, and if children are over the age of 18, they can be covered, but generally they have to have a disability. And there's a pretty strict definition of which children over the age of 18 will be covered. So if your child is married, I'm assuming that they're over the age of 18, they generally, assuming that they don't have a disability, they would generally not, you would not be eligible to take FMLA leave to cover them. All right, so it looks like quite a few of you have responded, so I'll flip through. It looks like this is actually pretty consistent with what I see from the clients who have called me about this. About 25% of you would say, yeah, let's go ahead and just allow Nancy to use her PTO without taking the FMLA leave, and another 75% are saying, no, we should really designate the time as FMLA leave. There's nothing legally that's wrong with scenario number one, but you are entitled to go ahead and go with choice number two, which is to designate the leave under the FMLA when you know that the leave is taken for a reason that qualifies for FMLA leave. In other words, when you know that someone is taking leave or taking time off for a serious health condition and they are eligible for FMLA, you're entitled under the FMLA to go ahead and designate that time. Now, importantly, the FMLA regulations state that it's an employer's responsibility to provide the notice of eligibility and rights and responsibilities to the employee and to timely notify the employee that leave is being designated as FMLA leave when you receive notice that the leave is being taken for a qualifying reason. And so you don't want to wait a long period of time and then attempt to retroactively designate a lot of time. I always like to say that we want to have these conversations early, and to the extent there's a disagreement, to document and to make sure that we are covering our bases instead of letting it go on for a long time and then deciding that we're going to do something different. There are a couple questions about why don't employees want leave designated, and I often get these questions, and you never really know what's going on in someone else's mind, but I think that some employees don't know a lot about the FMLA, and I think that others somehow think that it's a black mark, and so they don't want to use it, and they think that it will look better if they aren't categorized as someone who has used FMLA. Some employees don't want to use FMLA time because they believe that it's unpaid, and in that situation, I think that it's important for us to remind employees that PTO time can be used during FMLA leave. Many of your policies probably require that PTO be used during FMLA leave. And if you don't have a policy that requires it, employees can choose to exhaust their PTO during unpaid leave. And so that's something that's out there, and it's something that is generally a misnomer with our employees. Also, FMLA leave can and should run concurrently with workers' compensation injuries that require an employee to be off work and short-term disabilities. Other employees, I think, want to save their FMLA for a rainy day, so to speak. They don't want to use it unless they don't have any paid time off available. And there's a reason for that, because that would allow employees to essentially extend the time off that they have available and protected. So while I definitely recommend that you go ahead and designate the leave as FMLA, I also realize that you have to consider some practical pros and cons when you're doing that. The pros of designation are that the FMLA clock starts to run. If time off is taken for a serious health condition, and you allow the time to be classified as PTO and not FMLA, then you still have to provide FMLA when the PTO is exhausted. And so let's say an employee has a bank of 3 months of PTO, well then that employee could be off and under job protected leave for a period of 6 months. And that's a pretty long time when you're dealing with trying to get your organization and your university and the business done, especially under tight deadlines and tight staffing. Also, designating gives you some sort of consistency in the process. If you treat everyone the same way, there's no risk that employees can claim that they were treated differently than someone else. Bobby wouldn't be able to claim that Sally was treated differently than he was. And there's no risk that you're going to miss a step. If you have a consistent policy in place, and you make sure that it is followed every time a similar situation arises, then you make sure that you don't miss something. Because let's be honest, the deadlines under the FMLA to send the eligibility notice and notice of rights and responsibilities, and then to get the certification form, and then to send the designation notice, all of those steps are somewhat tedious. And if we miss a step, then technically we're out of compliance with what the FMLA says. Also, you have a record of the time that's going to be taken or has been taken for the serious health condition at issue. And you have a more accurate record of why the employee is out. Is the employee out related to that serious health condition? Are they out related to another illness? Maybe they get the flu and they take some sick time. You would be able to differentiate between that if you designate some as FMLA and others as PTO, sick, or vacation time. In contrast, if you allow the use of PTO, everything is lumped into that one bank, and you don't really know how much time has actually been taken for that serious health condition. And when FMLA expires and we get to the point of talking about accommodations for the employee, because the ADA still applies even when someone has run out of FMLA time, we want to know how much time the employee has actually taken over a period of time related to the injury or illness at issue. The cons is employee morale. Obviously, an employee who doesn't want to take FMLA time, who feels forced to take FMLA time, is maybe going to be unhappy about it. And there's also the risk that you would improperly designate something. In other words, employees who don't want to take FMLA time, usually they're not going to provide you that certification form, and so you're not going to have all of the information from the healthcare provider. Now, I think that this can be helped by a letter, and the letter would go a little something like this. Dear Sally, it's our understanding that you're taking leave based on XYZ condition. Based on our conversations with you, this is our understanding of your leave requirements. And this is an estimate of the amount of time that you have indicated that you plan to take. We believe that this qualifies as a serious health condition under the Family and Medical Leave Act, and therefore your time off for X condition will be designated as FMLA time. Let us know if our understanding of your circumstances is incorrect. And then, you say, we want to do whatever we can do to assist you. Please let us know what we can do to help, and we, look forward to having you return to work. And you would send that out with the notice of eligibility and rights and responsibilities and the designation notice within 5 days, business days of learning of the issue and the need for leave. Or you would just send that with the designation notice if you've already given the notice of eligibility and rights and responsibilities and the employee refused to provide a certification form. And that's usually when this issue comes up. Usually the employers are saying, you're eligible, please provide us the medical documentation, and the employees then say, hey, I'd rather just use my PTO time. And so at that point you could send that letter and essentially engage in the interactive process. So let's move on to the scenario number 2, which is Owen. Owen will be taking intermittent FMLA leave for planned physical therapy appointments. The appointments are expected to take Owen out of work for 2 half days each week for approximately 3 months. Owen's coworkers are frustrated because Owen's absences leave the team short-staffed unexpectedly. What are our options? And so this is something that you hear a lot. Employee has planned treatment, the employee needs to be out, we're not able to accommodate the absences. So how can we accommodate Owen's leave without impacting his coworkers or the university? 1, would we fire Owen? 2, would we ignore Owen's coworkers and just grant his leave, letting him come in and out as he needs? Or grant Owen's leave but transfer him to an available position that will better accommodate his planned medical treatment? So I'll let some responses roll in. It looks like 10% of you or so. All right, it looks like we've got about 35% of you, almost up to 50. I'll go ahead and flip through. It looks like we've got a good number of you who have responded. And this is actually really consistent with what we see as well. Some of you are saying, we can't handle it, so let's just fire Owen. That's a pretty strong minority. Some of you are saying ignore Owen's coworkers and just grant the leave, and some of you are saying, hey, let's look at transferring Owen to an available position. Well, aside from firing Owen, I think that you can do either one of these scenarios. And the reason that you can't fire Owen is because Owen, assuming he's eligible for the leave and he has a serious health condition, the time off is something that he's entitled to. Now, there are certain provisions for key employees and whether or not they're entitled to reinstatement, and that's the top 10% of earner's wages paid. And that's something that you would want to look at with someone in Owen's position, but that's something that you need to figure out at the beginning of the leave. And that doesn't necessarily mean that Owen doesn't get the leave. It just means that maybe he's not entitled to reinstatement. And generally that's something that you run into with continuous leaves of absence. So that's something that's kind of out there. But in general, Owen's going to be entitled to the leave. And so here's a little known provision of the FMLA that isn't used very often, but transfers are allowed for intermittent or reduced schedule leave that is foreseeable for planned medical treatment. Now this is really important. That part that I put in italics is there for a reason. The leave for a transfer to occur during FMLA leave, intermittent or reduced schedule, the leave has to be for a foreseeable planned medical treatment. It cannot be used for intermittent leave that is unexpected. So for example, an employee has migraines and they're going to need leave 3 times a month for 2 days each time. And the provider has absolutely no idea when those days off might occur. In that situation, you cannot transfer Owen. And I understand that most of you are sitting there saying, wait a minute, leave that is planned and foreseeable is leave that we might be able to accommodate in Owen's position, but it's the hard to schedule leave, the leave that we don't know about that's really hard for us to work around. And I 100% sympathize with you, but unfortunately the FMLA regulations are pretty clear that transfers are only allowed in this one situation. And when you look back at the hypo, you'll see that I designed it in a way where Owen is eligible for a transfer in this scenario, but this is a very limited scenario. In addition, when you can transfer, so when the regulations allow you to transfer, the position must have equal pay and benefits. That doesn't mean that the transfer position has to be equal duties. You can increase the pay of a position to make the pay and the benefits equal when you transfer. Also, you can't transfer Owen to a position that would require him to take more time off. In other words, if Owen requires physical therapy on Tuesdays and Thursdays, and you have a position that would allow Owen to work Mondays and Wednesdays, but would also require him to take off Fridays, you wouldn't be able to do that. You also can't transfer the employee to a position that would discourage his leave or create a hardship. For example, an executive should not be transferred to a laborer position, and a day shift position should not be transferred to a night shift position for your public safety officers. That's something that you should avoid. You also shouldn't transfer an employee to a location that is a significant distance away. You want to make sure that the transfer is not designed to discourage the leave or to create a hardship for the employee. Also, immediately when Owen no longer requires the leave, he is entitled to reinstatement to his old position. You want to be careful to the extent you have a unionized portion of your workforce that you're in compliance with the CBA when you're transferring, so that's something that I'll put out there. But it's something that you can use in your back pocket to kind of help your workforce a bit. So let's go to scenario number 3 with Aubrey. Aubrey told us last week that she's having knee surgery in 3 weeks. Aubrey said that she needs 12 weeks off to recover from the surgery. At the time of the surgery, Aubrey will have been employed for 48 weeks, so she has not yet been employed for 12 months. I'll give you that little teaser. Because Aubrey is not eligible for FMLA leave, what are our options? And let's assume, before I put up the questions, hopefully I haven't lost any of you, but let's assume that Aubrey's knee injury is a disability, because I know that's a question that you're generally going to have. So let's assume that Aubrey's knee injury is a disability. She's not yet eligible for FMLA. What do we do? 1, you could deny the request. 2, grant the request and designate the time off as FMLA despite that Aubrey is not actually eligible for FMLA. Or 3, grant the request as an accommodation. And these scenarios seem to come up fairly frequently that we hear, where employee is almost eligible but not quite eligible. What do we do? And I bet that these situations have come up in your own workforce. Just like FMLA leave or ADA is available, employees are protected by the ADA before they're eligible for FMLA. They're also protected by the ADA after they've taken FMLA leave. So I know I've seen a few questions that say, once an employee has exhausted FMLA leave, can we go ahead and terminate employment? And we're going to talk about a couple scenarios, but I'll tell you now that generally you can't terminate employment immediately when someone is just because they have exhausted their FMLA. You need to go through that interactive process under the ADA. All right, so we've got about 10% of you saying not eligible for FMLA leave. We'll go ahead and deny the leave request. Some of you are saying go ahead and grant the request and designate the time off as FMLA despite that she's not eligible. And the majority of you are saying grant the request as an accommodation. I would probably agree with the third option, that you should grant this request as an accommodation. It doesn't seem unreasonable. You want to consider ADA accommodations that engage in the interactive process prior to FMLA eligibility. The key here is that Aubrey is not yet eligible for FMLA, so ADA is going to be the appropriate authority. And employees are covered by the ADA on day one of their employment. In fact, I guess they're really covered as applicants because you need to provide accommodations to applicants as well. So while Aubrey's not covered by the FMLA, she is covered by the ADA. And so what you'd want to do in this situation is engage in the interactive process. The first thing that you would do is determine whether Aubrey's knee surgery is related to a disability. I gave you that one and said, let's assume that it is. If it is related to a disability, you would want to determine whether the few weeks of leave is a reasonable accommodation. And in this case, before the FMLA kicks in, we're talking about 2 or 3 or 4 weeks of leave. And that's probably a reasonable accommodation. So here's the tricky part. Part of Aubrey's leave, the first 4 weeks, won't be under the FMLA, and the remaining 8 weeks will be under the FMLA. That's something that you want to communicate about with Aubrey from the very beginning. When she requests the leave, you want to have that conversation. Give her the eligibility and notice of rights and responsibilities, making it clear that she's not eligible between X and Y date, but she will be eligible on Z date. And do the same on the designation notice that you send eventually so that there's no confusion about which part is going to be designated and which part won't be designated. You can use the certification form to obtain the information that you need to engage in the interactive process. So the FMLA, the same FMLA certification form that you would normally give, you can give that to the employee and use that information to engage in that process. I always receive the question, well, if we're going to go ahead and grant the leave, can't we go ahead and just designate it all as FMLA leave, even though Aubrey wasn't available? And the answer is no. You cannot designate leave as FMLA leave when someone isn't eligible. And so Aubrey will be entitled to 12 weeks after her 1-year anniversary. You can't limit her to 8 weeks after her 1-year anniversary because she took 4 weeks of leave before she was eligible. So that's something that the FMLA makes fairly clear, and the case law and the guidance, which is if someone is not eligible, the time that they take cannot be counted against their FMLA leave entitlement. And the way that these cases come up is, let's say Aubrey finishes this period of leave and then she needs another period of leave later in the same leave year. If we say, no, Aubrey, you already took 12 weeks and you don't have any time remaining, Aubrey could come back and say, no, you're interfering with my FMLA leave because really I only took 8 weeks of FMLA. I didn't take the full 12 weeks because I wasn't eligible for those first 4 weeks. And technically Aubrey would be right. And so I recommend that you stick with looking at whether or not the leave is a reasonable accommodation, granting it if it is a reasonable accommodation, and then starting the FMLA leave when the employee becomes eligible. So let's talk about Georgia. And many of these scenarios are based off of my kids and variations of my kid's name. My daughter's name is Georgia, and Georgia was kind of a sassy baby. And so you'll notice that Georgia in this scenario is a bit sassy as well. So Georgia has been employed for 13 months. Yesterday, Georgia began yelling at one of her coworkers out of the blue. She was cursing and threatened to fine the employee after work. Georgia's supervisor intervened, and Georgia was sent home. After Georgia left, her supervisor decided to terminate her employment for the incident and sent an email to HR confirming the decision. So Georgia's supervisor has decided to terminate her employment because of her inappropriate behavior at work. But as you can guess, the next morning Georgia returns to work, apologizes, and said that her behavior was a symptom of a mental illness, and she requested FMLA leave. So now what do you do? And here are the options that I've given you. Grant Georgia's request for FMLA leave and don't give her any corrective action for her behavior. Grant Georgia's request for FMLA leave with a last chance agreement or another strong corrective action, or fire Georgia. Georgia is, at my house, is 17 months old, and Georgia has finally started sleeping, so I feel a little bad for putting Georgia into this scenario now. But as a baby, it took her probably about 13 months to sleep through the night, and that's about when I wrote this scenario originally. So hopefully you can sympathize with why I put my daughter in this scenario, for those of you kind of wondering why the heck would you use Georgia here. She is cute as a button now, I will say. So this is a pretty common scenario, and there are variations of the same theme. Sometimes something happens to trigger the request for the leave. Sometimes we have an employee who is arrested, and instead of telling us that they were arrested, they call and request FMLA leave. Sometimes we find something out while the employee is on FMLA leave, and we get questions about whether or not we can terminate employment based on something that we discovered while the employee is on FMLA leave. So while this scenario is clearly something that led up to the request for FMLA leave, there are variations of this same theme, and for the most part, you're going to see very similar answers. So 10% of you would grant Georgia's request for FMLA leave without corrective action. We've got, it looks like the majority, 60% or so, would grant the request for FMLA leave with a pretty strong corrective action, a last chance agreement. And a third of you or so would terminate Georgia's employment. Frankly, you could go any way in this scenario. But I could support any option. I think the most conservative option is obviously granting the FMLA leave and doing nothing else. But that probably isn't practical or good for your workforce because it sets a precedent that you don't want to set. Violate a serious conduct rule, request leave, or make a complaint, or engage in any other protected activity. And that's probably not a precedent that you want to set. The FMLA leave is not a get-out-of-jail-free card. If an employee breaks a conduct rule and you make the decision to terminate, I would feel fairly comfortable going ahead and terminating employment in this situation. I think that you would have a strong defense to a claim of FMLA interference or retaliation based on the timing. And what I put in this scenario that I think is important is the documentation component. Prior to Georgia requesting FMLA leave, there was an email that went that said, we're going to terminate Georgia's employment. And so any sort of intervening event obviously did not cause the decision to terminate her employment because that decision was made before we even knew about it. Now, that's obviously the best case scenario, right? This is drafted by a lawyer for a webinar, and so I got to choose my facts. Sometimes those facts aren't quite as good, and we have to look at everything. But you definitely want to take a look at what makes the most sense. I think any of these solutions that you all had, giving a last chance agreement, that would be a perfectly fine way to do it if you want to send a strong message, but also be employee-friendly, so to speak. But if there's workplace violence, sexual harassment, discrimination of any kind, and you want to take a strong stance and say, no, we are not tolerating that, you are not required to accept breaches of your conduct policies or rules. The same is true if an employee is on intermittent leave and breaks a conduct rule. You're not obligated to accommodate an employee by accepting violations of your policies. That's probably the best way to put it. And so in some of these situations, you can probably take a more aggressive approach, but I would always recommend that you talk to counsel and kind of run through what the risks and the benefits are. And it definitely depends on how strong of a violation we're talking about here of the conduct rule. Let's talk about Dave. Dave has almost exhausted his FMLA leave, and while Dave was out on leave, we realized that our other employees could absorb Dave's work without any problems. Do we have to allow Dave to return to work? And so in this scenario, we realized, Dave, you've been out. We really don't need you as much as we thought that we needed you. Can we just go ahead and eliminate Dave's position or terminate his employment? So the scenarios are no, Dave has to be reinstated, or yes, Dave's employment should be terminated. And this is one that I bet several of you have experienced where, you know, the manager calls you and says, you know, hey, we moved things around when Dave went out, and now Dave's set to come back, and we don't really know if we need Dave anymore. Do we really have to give Dave his job back? These are definitely things that come up, and I think sometimes leaves like this kind of notify us of staffing issues. Sometimes you realize that you are far understaffed where you should have been, and sometimes you realize, hey, maybe we were overstaffed, and what exactly should we do with this? So it looks like we've got a good number of responses. About 90% of you are saying, yeah, Dave should probably be reinstated. And there's 10% that says, go ahead, let's terminate Dave's employment. I would say that I'm probably in the camp with the 90% of you, but there is an exception under the FMLA. The FMLA definitely requires reinstatement. There's no way around that, but there's one exception. Employees don't have a greater right to reinstatement than they would have had they been continuously employed during the leave period. And so that says that if an employee is laid off during the course of FMLA leave, the responsibility to continue FMLA leave, maintain the group benefits, and reinstate the employee will stop at the time the employee is laid off. And there's a specific FMLA regulation that's at issue. But it's the employer's burden to prove that the layoff was legitimate. So if an employee's position is eliminated, if the university is going through a position elimination program or a RIF or anything else, and the employee on FMLA leave is impacted, rightfully impacted, then you would not have to reinstate that employee. Similarly, if Dave is working on the night shift, or when Dave went out there was overtime that was available, and now when Dave comes back, overtime is not available. Dave isn't entitled to the night shift that's no longer available or overtime that's no longer available when he returns. But you really want to carefully scrutinize this. In this situation, you really want to look at why Dave is being chosen versus another employee who has remained. And so in this situation, if absolutely management is saying, we want to eliminate a position, we now realize that we are far overstaffed, you want to go through that process and fairly evaluate all employees in the area where Dave works and determine which person should be selected for the elimination using objective criteria. If you're only selecting Dave because Dave's the one who went out on FMLA leave and his absence was the absence that revealed that you were overstaffed, and that's the reason for selecting Dave, that would be very risky in my opinion. And so I think that probably what you would want to do is return Dave, let staffing go back to normal, and then determine what you want to do with the department or the group or the area when Dave starts working again, and analyze everyone. Dave shouldn't be selected just because he's on FMLA leave. You want to carefully consider any elimination and perform a non-discriminatory analysis of any sort of eliminations. And I think that's where this becomes risky. Dave's the automatic choice because Dave's the one that's out, and that's what makes it really risky. Scenario number 6 is about AVIT. For those of you fans of the Avett Brothers, my husband and I actually named our son after the band, and so this is my son, Avett. He is 3, or about to turn 3, so my daughter is 17 months and my son is 3. You're probably learning more about me than you ever wanted to know. In this scenario, Avett has a permanent disability that prevents him from performing the essential functions of his position. Avett has exhausted all available FMLA leave. Avett would like to remain employed and has asked to be accommodated. What accommodation should we consider for Avett, who is no longer able to perform the essential functions of his own position? None. Avett's employment should be terminated. 2, create a light-duty position for Avett, one that doesn't exist. 3, transfer Avett to another open position that is available, presumably. Or 4, allow Avett to apply and compete for another open position. So this is something that comes up a lot where, an employee stops FMLA leave or exhausts FMLA leave and comes back and says, listen, I am a coach or I am a public safety officer and I want to return to work for the university, but I can't return to work in my position that I'm assigned. And I don't know when or if I'm ever going to be able to return to work in that position, but I really love the university and I really want to stay. So what can I do, or what can you do to help me? That's normally how these sorts of scenarios go. And then the employer is left deciding, all right, what do we do? Do we create a position that doesn't exist? Do we transfer to an open position? Do we require the employee to compete? Do we do nothing? These sorts of questions come up pretty frequently. So let's see what your thoughts are. You all are pretty evenly split between the last two, transfer to another open position or allow him to apply and compete for an open position. Some of you are saying that you would go ahead and create a position that doesn't exist. And a few of you are saying we don't have any obligation in this situation. If Avett can't perform his job, he's not entitled to reinstatement, and so we will just move forward. So let's talk about whether you create a position or remove certain essential functions of Avett's current position permanently. That's never an obligation. You never have to create a position that does not exist under the ADA, even for temporary restrictions. And doing so, I think, can be risky because it's a really slippery slope of, well, why are you creating a position for this person and you're not going to create a position for this person over here? And so that's not something that you're required to do. Now, that's different than marginal functions. So there's a difference between essential functions and marginal functions that are not actually required for the position. And that distinction is sometimes difficult to determine what's essential and what's not. And you should be removing essential or functions that aren't essential, those marginal functions. So then the next question is there an affirmative duty to evaluate available positions for which the employee is qualified? And the EEOC and many courts take the position that if an employee cannot perform the essential functions of his or her own position, then under the ADA, you should evaluate other positions that may be available for the employee, that the employee is qualified for, and discuss those options with the employee. So the EEOC and the courts are saying, yes, if Avett's not eligible to or able to perform his position on a permanent basis, then you should look at other positions that Avett might be eligible for. But then that begs the question, does the employee need to apply and compete for the alternative position? And this is where there's a current circuit split by the federal courts, and the Supreme Court has not weighed in. Some courts say that the ADA is not a statute that requires preferential treatment, and you can require employees to apply and compete. Others have said that if a position is available and the employee is qualified, there is an affirmative obligation to offer that position to the employee without requiring them to apply and compete. So there's authority that is going in completely opposite directions. I can also tell you that even in jurisdictions that currently say, that have court precedent saying that yes, employers can require employees to apply and compete for open jobs, the EEOC is strongly investigating and taking up charges on this issue. This is an issue where the EEOC has taken the strong position of no, employees should not be required to compete for open positions for which they are qualified. Now obviously if a collective bargaining agreement applies and you have to promote or transfer employees based on seniority, then that would take precedence. But in a non-unionized workforce, the EEOC would say, no, if an employee is qualified for a position and they are unable to perform their current position, you should offer them the position for which they're qualified. So the safest bet is to not require the employee to compete. I realize that some of you your eyes are probably boggling out at the other end of the screen, and I will tell you that we don't know where the Supreme Court is eventually going to come down on this issue, so I can just tell you kind of what the risk is. And you may want to check with counsel about where you are and what your particular jurisdiction currently says on this issue. And so what if there aren't available positions that are open? At that point, there may not be a reasonable accommodation that's available, and you might get to the point of separation. In that case, I would probably write a letter outlining the restrictions as you understand them pursuant to your interactive process, and then outline the steps that you took to attempt to work within those restrictions. Note that there are no other jobs available for which the employee is qualified that would accommodate the restrictions, and then indicate that you can't continue to hold their position open, and so you really have no other choice but to terminate employment, and you would go forward from there. But you should probably look through or go through all of those other steps prior to doing that. So let's talk about Mary. Mary has FMLA leave for IBS. She takes several days off each week. Mary's FMLA leave is expiring next week, and she will not be eligible for more leave under the FMLA until March. Mary says that she will need a few days off each week for the foreseeable future. What do we do? Do we allow Mary to continue taking intermittent leave as an accommodation? Do we split Mary's full-time position into 2 part-time positions as an accommodation? Do we consider whether Mary is qualified for existing part-time positions, or do we do nothing and just terminate Mary's employment? Probably by now, you're thinking, well, the last answer is probably what Kate would say is the risky one, and so it's probably somewhere in those top 3, and you're probably right on that. That probably is what I would say. And obviously this scenario would go through kind of what most of you probably have is the rolling FMLA leave year scenario, where employees essentially earn back FMLA leave as they used it the year before, which is why Mary's been taking some intermittent leave. She's now run out, and she's not available for or eligible for another month or 2. So it looks like we're pretty split here between allowing Mary to continue taking intermittent leave as an accommodation or considering whether Mary is qualified for existing part-time positions. I think both of those are phenomenal ideas. And actually, I think thinking outside the box and thinking about whether you could split Mary's full-time position into 2 part-time positions as an accommodation also makes sense. I think the closer you get to March, the closer you get to saying, giving her 1 month of some intermittent leave as an accommodation probably doesn't seem unreasonable. But if we had done this webinar back in June and I told you, hey, she doesn't have any time off for 9 months, I bet more of you would be saying, we need to look at some other ideas as an accommodation, because 9 months of intermittent leave where essentially she's working on a part-time basis, that's probably not so unreasonable, or not so reasonable, I should say. And so it may depend on how much time we're talking about between when Mary is eligible for FMLA leave again, and how much leave, intermittent leave, she's actually taking. And looking at whether or not there are other part-time positions available, I think that that's a phenomenal idea, and it really goes back to the last scenario that we talked about. In terms of splitting Mary's part-time position or full-time position into 2 part-time positions, that's really thinking outside the box. It's not necessarily something that you're required to do, but it's certainly something that you may want to consider, especially if you think that, that is possible with the position that Mary's in. A lot of positions that might not be possible, but that's what the interactive process is for you to, kind of think through some of these scenarios and think about what you might be able to do to assist. So let's talk about our last scenario, which is Bernadine. That's my daughter's middle name. Bernadine is employed in an accounting group. Bernadine informed us that she has narcolepsy and is no longer able to drive to and from work. Driving is not required for Bernadine's position. So Bernadine is basically saying, I can't get to work. So now we're asking, what, if any, accommodations should be considered for Bernadine, who's unable to just get to her job? Are you required to secure transportation for Bernadine to and from work? Should you consider whether to allow Bernadine to work from home? Or should you do nothing because everything you could think of would be unreasonable? And this is something that in the electronic age of workforces, we are coming across more and more. Before this time, probably even 10, 15 years ago, we weren't talking as much about this. And if an employee couldn't get to work, their work needed to be done at work. And so we weren't talking about accommodations in these scenarios as much. But now we're talking a little bit more about these sorts of scenarios. Looks like you guys were quick. You're probably about ready to stop hearing my voice, I would anticipate. So we've got a few of you that talked about securing transportation, that might be something that you would consider. The majority of you are saying consider whether to allow Bernadine to work from home. And some of you are saying do nothing, everything is unreasonable. I think that you probably came out, the majority probably came out right on this scenario. For the most part, commuting assistance is not required as an accommodation. The accommodations that are required are accommodations that will allow the employee to perform the essential functions of their job, and you are not required to go pick up an employee. Now, a small exception might exist if, for example, you have a transportation in the town where your university or college is. And that transportation is used to pick up students from off-campus housing and transport them to school. If you have something like that exists and it is solely for student use, it might not be a reasonable accommodation for you to think through whether or not that bus can also be used for the employee to get on to help get them to work. That could be, in this scenario, a reasonable accommodation. And there are courts in very limited circumstances, such as the one I just described, where that is something that they consider to be reasonable. In addition, more and more working from home is considered a reasonable accommodation. So if for some reason an employee is not able to work in the work environment, sometimes we see this with employees with really strong allergies, where they cannot be around certain, just everyday chemicals that would be anywhere, that they may be able to work from home. With accounting, I think that that's probably on the line. I think that you have to determine what exactly this employee does in the accounting group, but certainly looking at that as an option is the right way to go, and it's something that you should consider and discuss during the interactive process. Now, I hate to tell you because I bet we have a lot of HR professionals on the phone, but there was a recent case that came down that said that HR, it would not be a reasonable accommodation to have an HR person working from home because HR should be in the office and interacting with the employees, and part of the essential functions would actually require presence in the office. There are a lot of jobs, management, other things like that, that actually requires a presence in the office to do. But you want to take a pretty close look and determine where you're going to come down on that for the job at issue. And it doesn't have to be an across-the-board decision. One job might be able to be performed from home while others cannot. So here are some takeaways from today. We recommend that you have consistent policies and procedures in place for designating FMLA leave, and that you follow those policies and procedures for every absence or leave request that may be related to a serious health condition. When the FMLA does not apply, either before an employee is eligible for FMLA leave or after FMLA leave has been exhausted, you should consider whether additional leave is a reasonable accommodation. And when the FMLA doesn't apply, consider accommodations such as transfers or telecommuting. Think outside the box during that interactive process. You want to consistently enforce your conduct policies, and those can be applied regardless of whether someone has a disability or is on FMLA leave. And in many of these situations, we're in the gray area, and so obviously I'm going to do the shameless plug, but seek legal counsel. Whoever your preferred counsel is, they are happy, I'm sure, to answer any sort of questions you have on these issues, and we are, of course, happy to answer any questions that you have on these issues. I know that I did not get to many of your questions, although I think I covered several of them that I kind of saw popping up, but I will answer those questions and I will email you my answers in the next several days. I want to thank you for joining me for our program today. I really hope that the information that I provided was helpful and practical for your organization and for you. If you've not already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, the program has been approved for Colorado, Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin Continuing Legal Education Credit and HR Certification Institute and Society for Human Resource Management Recertification Credit. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with your certificate of attendance, and that should come tomorrow. And this concludes our webinar. Thank you so much for attending.